Please be seated. The court is now in session. This morning, the Chamber will continue to hear the testimony of Mr. Richard Dartman via a video link from the United States of America. And for the afternoon session, commencing from 1 p.m., the Chamber will hear the statements of impact by two civil parties who claims to suffer harms during the Democratic Cambodia period. And the graphic, Mr. Chia Siu Huang, could you report the attendance of the parties and individuals to today's proceedings? Chia Siu Huang. Mr. President, for today's proceedings, all parties to discuss are present. As for Noon Chi, he is present in the holding cell downstairs as he requests to waive his rights to be present in the courtroom. His waiver has been delivered to the greffier. The witness who is to testify today, that is Mr. Richard Dartman, by a video link from the United States. And the AB unit confirms that the link has been connected for the proceedings, and the witness himself is ready to testify. The civil parties who are to testify this afternoon there are two of them, 2 TCCP 982 and 2 TCCP 985. President, thank you, Mr. Chia Siu Huang. And the Chamber now decides on a request by Noon Chia. The Chamber has received a waiver from Noon Chia dated 1st April 2015. He confirms that due to his poor health condition, that he had headache, back pain, and that he cannot sit for long. And in order to effectively participate in the future hearings, he requests to waive his right to participate in and be present at the 1st April 2015 hearing. He has been informed by his counsel about the consequence of this waiver, that in no way it can be construed as a waiver of his rights to be tried fairly, or to challenge evidence presented or admitted to this court at any time during this trial. Having seen the medical report by the duty doctor for the accused at the ECCC, dated 1st April 2015, who notes that the health condition of Noon Chi is that he has chronic back pain when he sits for long, and recommends that the Chamber shall grant him his request so that he can follow the proceedings remotely from a holding cell downstairs. Based on the above information and pursuant to Rule 81.5 of the ECCC internal rules, the Chamber grants Noon Chi his request to follow the proceedings remotely from a holding cell downstairs via an audio-visual means for today's proceedings, as he waives his direct presence in the courtroom. The AB unit is instructed to link the proceedings to the room downstairs so that Noon Chi can participate in and follow today's proceedings remotely. President, and good morning, Mr. Richard Dartman. Are you ready?
I am ready, Mr. President.
Thank you, Mr. Dartman. And the Chamber now hand the floor to the lead co-lawyers for civil parties to continue putting questions to you. And Madam International Lead Co-Lawyer for Civil Parties, you have the floor.
Thank you, Mr. President. We have no further questions for the witness.
President, thank you. And now the Chamber hands the floor to Kills and Pawns Defense. Counsel, you may proceed.
Thank you, Mr. President. Good evening, Mr. Dudman. I am Anta Guissé, and I am the co-international counsel for Mr. Kesampan, and I'm going to put a few questions to you. It shouldn't take too much time. Good morning. Good evening. When Elizabeth Becker testified before this chamber, she spoke about the preparations for your trip to Cambodia in December 1978. And this is what she said. And here I'm going to quote from her book, When the War Was Over, in French, Les Larmes du Cambodge. The ERN, and the excerpt I'm going to quote from is at ERN 00638-654 in French. English 00238-115. On page 402 in the English version. And this is what she says regarding the preparation for your trip. This is a free translation. Dudman and myself had been informed of the critical situation in Cambodia before we arrived. I spoke with experts from the State Department, from the Ministry of Defense as well as from the CIA in Washington. In Bangkok and in Beijing, I met military and political experts from the USA, from France, from Canada, from Australia, and from China. None had predicted a large-scale war between Vietnam and Cambodia. According to them, at worst, the Vietnamese would try to reach the Mekong and would just stop there, just happy to control the eastern bank of the river before attacking the capital at a later date. One of the most eminent American experts, who was an old friend, said that my fears about the war and about my own security were without any grounds. He said it will be a piece of cake. That's end of quote, free translation. So my first question is, do you remember if you took any caution, just like Elizabeth Becker, and had gathered information on the situation in Cambodia before you prepared your trip in 1978?
I do not remember what preparations I made. I'm sure I talked to many people, including officials, and but I can't recall what I did exactly.
And do you remember if you were told that there was nothing, that you shouldn't fear an immediate attack from the Vietnamese?
I don't remember any such assurance that I received.
And regarding this latent conflict between Cambodia and Vietnam, while you were preparing for your trip and while you had documented yourself on the region and in particular on Vietnam, did you do any research on the border issues between Cambodia and Vietnam, and in particular with regard to the Brevier line?
I don't recall what research I may have done.
Il y a 2 jours,
2 days ago, or yesterday, I don't quite remember, you listened again to Pol Pot's statements when you interviewed him in 1978. And in the excerpt that was played during the hearing by my colleague from the Nguyen Chia defense team, in fact, it was yesterday, I can confirm that, Pol Pot spoke about the Vietnamese expansionist ambitions and also spoke about the fact that it was not only a border question. So do you remember that part of that interview? And did that match what you knew about the situation back then? Does that match what you knew about the Vietnamese political ambitions?
I don't remember that conversation, so I don't know how to compare it with what I knew at the time.
est-ce que vous...
Do you remember back then that we were in the midst of the Cold War, and Pol Pot spoke about this when he spoke about a rapprochement between Vietnam and the Soviet Union? Does that ring a bell in relation to the events back then?
I don't recall.
Dans votre...
In your report of January 1979, this is document E3/3290 at ERN 00419-207. You speak about the Chinese presence in Cambodia, and this is what you said. I will quote in English because this document has not been translated into French. For the French interpreters, it is just before the paragraph "Where are the rich?"
Travels, did we see any sizable body of Cambodian troops or weapons? And the only signs we saw of Chinese assistance in the country were 2 MiGs flying over Phnom Penh one day and a line of 56 Chinese trucks driving north from Kampong Som, where a Chinese freighter had discharged them. Fin de citation.
End of quote. Mr. Dudman, does this jog your memory? And do you remember having seen 2 Chinese MiG fighter planes flying over Phnom Penh?
I do not remember that.
Lors de sa
When Elizabeth Becker testified about Caldwell's death, and when she spoke about the different hypotheses that were formulated back then, in your report, again, E3/3290, this is what you write, and I will quote in English, and you speak about what was said by Chun Prasit.
Prasit described the shooting as a political act to to discredit us in the world and to show that we cannot protect our friends. He said the terrorists knew that the visit of the first 3 Westerners to Cambodia was a significant one and that Cambodia's reputation in the world would be greatly damaged if they were assassinated. Only days later, that Cambodian regime would be driven into hiding by a Vietnamese assault. Fin de citation.
End of quote. Here again, same question. Does this jog your memory? And do you remember Chun Prasit speaking about the hypothesis of a Vietnamese attack?
I didn't understand your question.
Je vous demande.
I am asking you if you remember this segment of your report, and if you remember Chun Prasit speaking about the possibility of a Vietnamese attack, of a Vietnamese terrorist attack, as maybe one of the reasons for the murder.
I really don't remember my thinking at the time. I have only what I wrote at the time was what I knew then, or thought I knew, but I don't have any recollection of anything further.
Dans le même rapport.
In the same report, you also spoke about what Yang Sari said at the same ERN 00419-212, and I will quote in English again.
Yang Sari said sadly that the visit had been intended to present to the world the concrete situation in his country, but that the terrorist incident had cast a very dark cloud on this effort. The Cambodian government later attributed the terrorist act to Vietnam, its enemy in a current war, in which there was a temporary lull at the time of our visit. Fin de citation.
End of quote. So, same question again. Does this passage of your report jog your memory? And this...
Dernier extrait.
And the last excerpt I'm going to read out regarding your report. You spoke about you said when you answered the co-prosecutor's questions 2 days ago, and that there was quite a bit of speculation back then, and you remember that there was a lot of rumors following Caldwell's murder. And this is what you said at the end of your report regarding the possibility of an attack that may have been instigated by the Khmer Rouge government itself. And this is what you said.
Was there any possibility that the government could have arranged the attack? A dispatch from Hanoi later reported that Caldwell had recently turned against Cambodia and conjectured that the government may have wanted to prevent what they feared would be an adverse report. This seems out of the question. The Cambodian government had everything to lose from the incident. If, for some uncountable reason, the authorities had wanted us killed, they could have contrived an accident or ambush to kill us all. And from lengthy conversation with Caldwell up to a few hours of his death, I know that he remained fully sympathetic to the Cambodian revolution. Fin de citation.
End of quote. So my first question, do you remember your conclusions back then with regard to the murder? And do you remember that particular conclusion? And was that what seemed plausible to you in 1978? That is to say that the Cambodian government had no interest in fomenting such an attack.
I have read just today, and again, what I wrote at the time, but I have no recollection of what led me to write that. I don't remember those circumstances.
Bien.
Fine. Thank you for your patience, Mr. Dudman, and I have no further questions. Thank you.
President, judges of the bench, do you have any question you would like to put to the witness? It seems that the bench does not have any question. And this morning's proceeding will adjourn now, as it ends before the scheduled time. And we will resume the proceedings again at 1 o'clock this afternoon. And for the afternoon session, we will hear the statements of impact by two civil parties who claims they suffered harms under the Democratic Cambodia regime from the 17th April 1975 to the 6th January 1979. This information is for the parties and the general public. And Mr. Richard Dudman, the Chamber is grateful of your time and testimony, and your testimony will contribute to ascertaining the truth in this case. And the hearing of your testimony is now concluded, and you may be excused, and we wish you all the very best. And the Chamber would also like to thank the two counsels, that is Mr. Todd Lowell and Mr. Jason Barrett, for your assistance in the testimony of Mr. Richard Dudman. And the testimony is now concluded, so you may also rest. Thank you.
Thank you, Mr. President.
Thank you.
And goodbye, Mr. Richard Dudman. And the Deputy International Co-Prosecutor, you have the floor.
Yes, before we break, Mr. President, yesterday I mentioned my recollection that an issue we discussed yesterday that had been raised by the Noon Chia team, questioning or challenging the use of victim impact statements relating to the facts of the case. I did look at the transcript, and I did find where this issue was discussed and ruled upon. On the 20th of May 2013, this was about 1 week before the victim impact testimony was to begin, the court scheduled argument at the end of the day to hear from the parties on the issue of to what extent the prosecutors and the defense would be allowed to question the civil parties during the victim impact. You'll find this at pages 100 to 111, end of that, of the 20th of May, E1 /193.1. My colleague, Mr. Rayner, made 10 points to this court that emphasized the importance of being able to rely on factual information from these civil parties. He emphasized, quote, that civil parties should be questioned on all issues of relevance. that evidence relating to suffering and the occurrence of the crimes was inextricably linked. He talked about how the civil parties were victims of forced movement, whose evidence would go to the heart of the trial. He noted that the defense should be provided the opportunity to challenge that evidence. He stated, I quote, "Both the prosecution and defense have been proceeding on the basis that full examination would take place," end of quote. And he noted the duty of the chamber to ascertain the truth, which mandated that these civil parties testifying in the victim impact phase be treated the same as prior civil parties. In response, this is what Mr. Kope, Noon Che's counsel, said, and I quote, "Mr. President, I don't think I would ever be saying this in a court of law, but I think I agree with all 10 submissions from the prosecution. So we fully concur with the submissions of the prosecution." He was then followed by the Q Sampan defense, Mr. Verkin, who also concurred with our position. Let me quote him. "Bringing people here for them to speak only about their harm suffered, without them explaining the reasons and experience that led to this harm, seems unusual to me and incongruous in such a trial. It's difficult to distinguish the origin, the factual aspects of the harm from the harm itself." He concluded, "It seems to me that it is normal, if these people come next week, that aspects linked to harm slide to some things that are factual. We will manage as we can, faced with the situation, in order to try to examine them." The next day, on the 21st of May, again at the end of the day, this is a document, the transcript for the 21st of May, 2013, E1/194.1, on page 119 in English. The trial chamber issued its ruling on this issue, stating, I quote, "There has been a mutual consent amongst all the parties, and the chamber decides that the parties may question the civil parties on relevant factual issues subject to the time limitations already announced." So when we started the victim impact proceedings, everyone in this court knew that they would be examined not just on harm, but on the relevant facts. That is why all the parties asked questions on that, and that is why this chamber cited that evidence in its judgment. It's very unfortunate to me that these arguments were put to the court yesterday. It's not an isolated incident in the appeal brief that was filed by the Noon Chea team. And on a going forward basis, I might suggest that where the Noon Chea team wishes to make motions to this court, it file a motion and not simply attach portions of an appeal brief which are being litigated before the Supreme Court. We take issue with many, many characterizations like this, which misstate what has happened before this court. In any event, it's important that the record be clear that in the past trial, this court announced very clearly that these civil parties would be examined on factual issues, and the same should happen today when we start. Thank you.
President Judge Fans, you have the floor.
Perhaps it's easier if I add something and then you can answer to both. In this context, I would like to refer to a decision the Noon Chea team has referred to in their appeals brief, and that's E267/3 from 2nd of May 2013. So my guess is that
ជាមិនមានការបកប្រែ
There seems to have no translation. Can you check the AV unit?
ជើងលោកត្រូវជាក្រុមចាប់ដាក់
President, Judge Vance, could you please repeat what you had just said?
Yeah, I just wanted to add that there was a decision E2673 from 2nd May 2013 dealing with the issue at hand, and I guess it was probably the basis for the debate in court a couple of days later. It was also referenced by the Nunchia defense in the appeal. And specifically, page 9 of this decision appears to deal with all the issues raised yesterday by the Nunchia defense. It clearly says that cross-examination will be allowed. And it also clearly, in paragraph 21, says how, generally, how the trial chamber will deal with civil party statements, including impact statements, on trial level. The reason I didn't mention it yesterday is because since it was mentioned in the appeal, I thought it was obvious, and the only thing I tried to do is highlight what I thought was probably a misquote of another decision. But just to add to the arguments. Thank you.
Thank you, Judge Vance. And in reaction to what the Deputy Co-Prosecutor just said, of course, yesterday I revisited our appeal brief, and I also revisited the decision of the trial chamber in this respect. It seems to me we have a completely different interpretation as to the ruling on this matter by the trial chamber. To me, it seems clear there's a distinction between testimony given by witnesses or civil parties normally, while sitting there and giving testimony to the facts, and the phenomenon of civil impact testimony. Now, obviously, if a civil party talks about the suffering, he or she would relate to some underlying facts. However, the whole idea of the distinction also made by this trial chamber is that it is in essence no evidence, evidence that will not be used against the accused ultimately in its judgment. That's how we understood it then, and that's how we still understand your decision. You've seen in our appeal brief that we've quoted your decision, and the mere fact that it is only 10 minutes time that was allotted to us to ask some questions to the civil party giving civil impact testimony is one element that confirms our interpretation and understanding. The fact, as mentioned yesterday, that you asked the defense's permission to continue while Nguyen Chia was absent because of sickness confirms this interpretation. We have been always acting on the basis of a fundamental difference in suffering testimony on the one hand and real testimony to the evidence on the other hand. At the time, and that is in response to Deputy Co-Prosecutor Lysak, at the time, of course, we were fully agreeing with Prosecutor Keith Rayner when we said that we needed equal opportunity to question witnesses. However, that was not the standard practice. The standard practice was you have another 10 minutes to ask some follow-up questions. Plus, I think we should be reminded of a difference between, on the one hand, a civil party coming here to testify, and then at the end giving civil impact testimony, and this whole group which is now scheduled, which is just coming here for half hour or for an hour. In any case, I believe, and that's the reason of our appeal, there is a very different interpretation possible as to what the law is. We on the defense team are lawyers. We read your decision, and if we see things wrongly, then the Supreme Court chamber will tell us. And if you see we see things wrongly, then of course we would accept that at this stage in these proceedings. But to us, there is unclarity as to what the law is. And if you're saying this is how we should interpret your decision, then we will arrive at our alternative. Our proposed alternative is that we need the equal time to question the upcoming civil parties. So that's, I think, how it should be interpreted. And that's how we should see, you should see our appeal brief. And last remark, following some remarks of the co-prosecutor, the reason why we just send you excerpts from the appeal brief is because of reasons of expediency and of fastness. That's the reason that we did it. We simply do not have the resources to always come up with full responses to motions, especially in light of the fact that the civil party testimony, impact testimony was already scheduled. So again, summarizing, what apparently seems clear to other parties didn't seem clear to us at all.
President, you may now proceed. The counsel for Mr. Kyosampon.
Je vous remercie, Monsieur le Président.
Thank you, Mr. President. I'd like to say something very briefly. I'd like to quote one of your memoranda, document E236/5/3/2, in order for you to understand the substance of my submission yesterday and our understanding of your decision regarding the two types of testimonies, that of a civil party testifying to facts and a civil party appearing to present his or her sufferings. So this memorandum, which deals with TCCP 13, the civil party who testified, this is what you stated. The purpose of hearings devoted to the incidents of crimes alleged on victims is to give the civil parties an opportunity to present evidence in support of their application for moral and collective reparations, Rule 2.3 of the internal rules. End of quote. Free translation. To my understanding, when we talk of lack of reparations, we are already in a second stage. That is, we would already have decided that there would be a conviction, and we are now interested in an application for reparations. As far as we are concerned, and that is why during the first trial we did not examine the civil parties at length as to their sufferings, because we understood that there was a distinction between the hearings, in respect of which they were appearing as witnesses to facts at the same time, and those that were devoted exclusively to the application for moral and collective reparations. And that is how we understood your memorandum. So it is very clear that, as far as we are concerned, it is not a question of saying that effectively we can distinguish between the facts and the sufferings, because we need a minimum basis for the civil party to refer to facts experienced by that civil party and facts that have to be considered by the chamber in view of the reparations applications. And it is normal to have application for reparations when there is a guilt, a finding of guilt. That is why we needed this clarification today, because we noted in paragraph 30 of our appeal brief that there was a massive use of statements by civil parties that were supposed to be related only to the application for moral and collective reparations, which were used as prosecution evidence. And that is why we made our application, and we are bearing in mind the fact that we have always tried to show proof of foresight in the questions that we ask, and which we intend to continue asking. And if there are any new elements, any new facts, and it is not always easy for us to know which are new facts because we do not have enough data on the civil parties before they appear, and it's only in the course of their testimonies and representations that we realize that we need more time to cross-examine them.
President, you may now proceed. Deputy International Co-Prosecutor.
I'll be very brief. What we just heard is revisionist history. Read the transcript from the 20th of May 2013. There is no ambiguity. There is no room at all for Mr. Kope and the defense to suggest that they were unaware of the purpose of the victim impact civil parties. It could not be clearer. The exact issue we were discussing was the extent to which the civil parties heard in victim impact would be testified about factual information and whether that could be used. That was the issue. Read the 10 points from Mr. Rayner. Read the responses from the defense counsel. This is crystal clear. This is an issue that they have made up after the judgment, after losing. It is as simple as that.
President. So the chamber does not allow any further submission or observation because we have been in 2 rounds already. The chamber informed the parties already yesterday that the chamber is well informed, and we will take this matter into consideration. Security personnel are instructed to bring Mr. Kyu Sumpon back to the waiting room downstairs and bring him back to the courtroom this afternoon at 1 o'clock. The court is now adjourned.